So if a loved one passes away, they own a home, everyone assumes the house just goes to the family. But in reality, that's often where the stress, the confusion, and the expenses really begin. You guys know I'm Shannon and I've got some experience in working with families and homeowners in this scenario. In this video, I'm gonna walk you through what actually happens to a home when the owner passes away. If there's a will, if there's no will, and how different types of trusts can save your family time, money, and heartache. Whether you're a homeowner planning ahead or an heir suddenly dealing with an estate, this will give you clarity and a game plan. So what really happens when someone dies owning a home? We'll start with the big misconception. Owning a home does not automatically mean it just goes to your spouse or kids smoothly. When a homeowner passes away and the home is not in a trust, the property usually has to go through a legal process called probate. And probate is a court-supervised process where a judge oversees who's in charge, and ultimately who gets the property and on what terms. During probate, heirs usually cannot sell the home or change title freely until the court gives some authority. It can take months or often a year or more depending on the complexity and the court's backlog. Everything is also public record: who inherits, roughly what the estate is worth, and who's fighting over what. So heirs, if you're expecting to quickly sell the home or move in, probate can be a surprise roadblock. For homeowners, this is where planning ahead makes a huge difference to your family. The cost of probate and why families get shocked. So we'll talk about the money side because this is where most families say, we had no idea. In probate, there are typically court filing fees, publication costs, public notice in newspaper, attorney's fees, personal representative or executor fees. And in many cases, those legal and executor fees are calculated as a percentage of the gross estate value, not the equity. So if your home is worth $2 million, the percentage is based on $2 million, not what's left after the mortgage. For a 7-figure home, it's very common to see tens of thousands of dollars eaten up in probate-related costs. That's money that could have gone to your family, to charities, or to investments, but instead it goes to the process. Also remember, probate is slower, it's public, and it's more extensive than that well-designed, trust-based plan in most situations. So with a will versus no will. Now let's break down these two very common scenarios. When there's a will, but no trust, a lot of people think, I have a will, I'm covered. Here's the truth. A will controls who you want to receive your assets, but a will does not avoid probate if the estate is over the small estate threshold and the home is not in a trust. What the will does, it names the executor, the person you choose to handle your estate, and it gives your instructions: who gets the home, whether it's sold, how proceeds are divided. What it doesn't do, doesn't keep you out of court. It doesn't keep things private, and it doesn't necessarily make things fast or cheap. So I have a will is better than nothing, but it's not the same as having things truly streamlined for your heirs. So number 2, when there is no will, this is called intestate. If you die without a will, you don't avoid probate, you just let the state law decide for you. When there's no will, the law decides who inherits, typically your spouse and children first, then parents and siblings, and so on. The exact split can get complicated, especially with blended families, second marriages, or kids from prior relationships. Family members may be surprised by who legally has rights to the home and in what proportion. For their heirs, this can cause conflicts between surviving spouses and children, co-ownership between people who don't get along, and forced sales when some heirs want cash and others want to keep the home. From a planning standpoint, no will basically says, I'm okay with the government's default plan, no matter what that does to my family. Next is joint ownership and TOD deeds. Before we move into trusts, let me briefly touch on 2 things you may have heard of: joint tenancy and community property with right of survivorship. If a married couple or co-owners hold title this way, the surviving owner usually receives the deceased owner's share automatically. That can avoid probate at the first death, but often not at the second. Transfer on death, or TOD deeds, in some cases an owner can sign a deed that names a beneficiary to receive the home at death. It can avoid probate, but it has technical requirements and can lead to issues in a more complex family or tax situation. So these tools can help narrow scenarios, but they're not a substitute for a comprehensive estate plan, especially when there's a significant amount of equity, multiple properties, or blended families. Now let's talk about the tool that most families rely on, the Revocable Living Trust. Think of a Revocable Living Trust as a custom set of instructions plus a new bucket to hold your assets while you're alive and after you're gone. Here's how it generally works. You create your trust during your lifetime. You typically serve as your own trustee and beneficiary while you're alive, so you stay in control. You retitle your home into the trust name, you name a successor trustee who steps in if you're incapacitated or when you pass away, and you spell out who gets the home on the sale and proceeds and on what terms. The key benefits: it avoids probate on the assets properly titled in the trust. Faster and often far less expensive than full probate, and it's private, not a public court case. It handles incapacity. If you're alive but unable to manage things, your successor trustee can step in and manage the property without going to court. An important point that gets missed: the trust must be properly funded. The deed to your home never gets changed into the name of the trust. That home may still end up in probate, even if your trust document is beautifully drafted. So for homeowners, the trust is the plan, but the deed is the implementation. For heirs, if you're told there's a trust, one of the first questions is the home actually titled in that trust? Now, not all trusts are the same, so let's keep this part really simple. A revocable living trust means you can change it, amend it, revoke it during your lifetime. Primary goals are to avoid probate, keep things private, make it easier on your heirs, and plan for incapacity. Generally does not give you strong protection from your own creditors or lawsuits while you're alive, because you still control the assets. Now, an irrevocable trust is much harder or sometimes impossible to change after it's created. You typically give up direct control and ownership of the assets placed into it. Because of that, in the right situations, offer asset protection and tax planning advantages. Common uses include keeping certain assets like life insurance outside of your taxable estate, providing long-term management for beneficiaries who shouldn't receive large lump sums, and certain long-term care or benefit planning strategies when done correctly and early. For most homeowners, the starting point is a revocable living trust for probate avoidance and ease of administration. Irrevocable trusts are more specialized tools that should be designed with qualified estate planning attorneys, especially when asset protection or tax issues are the main goal. So protection for heirs, what does this look like in real life? I'll just quickly paint a picture so you can see the difference. Scenario A, no trust, no plan. Owner passes away with a home worth, say, $1.5 million. No trust, maybe a basic will, maybe not. Heirs have to open probate, hire an attorney, wait for the court to approve everything. They may wait many months before they can sell or refinance. They may pay tens of thousands of dollars in fees and costs, and family disagreements get magnified because they're now inside of a public legal process. Scenario B, a revocable living trust in place. Home is titled in the trust. The owner passes away. Successor trustee steps in almost immediately. The trustee can work with professionals to sell the home or distribute it according to the trust instructions. No full probate, much less court involvement, process is faster, usually less expensive, and private. Heirs know who's in charge and what the rules are because it's all written out. Same house, same family, very different experience. So a message to homeowners: if you're watching this, your home is often your largest asset. The way it's titled and the plan around it will directly impact how easy or difficult things are for the people that you love. A thoughtful estate plan, usually anchored by a revocable living trust, can save your family time, money, and conflict, and keep your affairs private. So your action steps: review how the title is currently held on your home. If you already have a trust, confirm the home is actually in the trust. Work with an experienced estate planning attorney to make sure legal side aligns with your goals, and coordinate that with your real estate strategy, tax planning, and overall financial plan. A message to the heirs: if you've recently lost someone and you're now dealing with their home, first, my greatest condolences, but give yourself permission to take this step by step. This is an emotional and complicated process. Gather your documents, the deed, any trust, any will, recent mortgage statements, property tax bills, and insurance, and figure out, was there a trust? How is the property titled, and is probate required? Then talk with a professional team, an estate planning or probate attorney, a knowledgeable real estate professional, and potentially a tax advisor to create a plan. The decisions you make about selling versus keeping, refinancing or renting, or buying out other heirs can have major financial and tax consequences. You don't have to navigate this alone, and you shouldn't. Estate planning isn't just about documents, it's about making things simpler, clearer, and more dignified for the people that you care about most. If you're a homeowner who wants to make your family protected and an heir who's facing decisions about property after a loved one passing, I'm here as a resource. We can walk you through it, how the home is currently titled, what probate would likely look like for your situation, and what options you have to make things smoother and more efficient. As always, I'm Shannon Ellison, here to educate and navigate not speculate and fabricate. If this was helpful, share it with someone who owns a home or someone who just inherited one, and subscribe for more real estate planning insights designed to protect you and your family.